Good afternoon. It is Monday. I believe the date to be September the 1st. Here we go. We're in the last 3 months of the year, the last quarter of the year, guys. I'm a former accountant, so I kind of live my life in quarters. So, yeah, I pay attention to that. It's kind of weird, I know. But anyway, all right. What I have right now is the actual motion to dismiss the felony information on Fifth Amendment grounds in the case of State of Arkansas versus Aaron Spencer. This is in the Circuit Court of Lonoke County, Arkansas, First Division, case number 43CR-24-551. Okay, we're going to go through this, guys, and I'm going to tell you right now, there are some words in here that I literally cannot make my lips form to say the word. Okay, so some of the words in here I have replaced with words that mean the same, but that my mouth actually will say. And that's very rare because usually, my vocabulary is pretty good, but yeah, when it comes to these, court documents, they use a lot of Latin. Thank goodness I took 3 years of it. But still, even still, it's still, like I said, I just can't make my mouth form the words. So, we are going to get started here. You know what? It would help a lot if I put my glasses on. I'm really excited about this motion, and I'm really hoping that we can get some traction with this. I mean, I've read through this thing 3 times now, and it's very valid. Just the problem is, even though there is the argument for it, I believe that the state of Arkansas, if Judge Elmore chooses to do so, I still believe that they can go ahead with this case as it is. Now, I may be wrong because, like I said, I am not an attorney. Okay, I just have a large interest in law. My sister and my brother-in-law, they were attorneys. I have a huge interest in it, mainly because I've had to use the law for my benefit, and then I've also had to defend myself, um, against fraudulent charges, and I did it, and it's hard. It is hard. It's hard to walk in a courtroom pro se. Um, but I will say, I walked into that courtroom the first time I did pro se was during my divorce from my husband, and it was a custody battle, and I represented myself. But big but, he actually paid a pretty well-known attorney, and so he actually had an attorney. Um, the problem was, though, your attorney can only do the best that they can for you if you're honest with them. Well, that was the problem with my ex-husband, was that he couldn't be honest with his attorney, and so his attorney, I'm representing myself, and I actually have evidence and witnesses and all such as that, pictures, letters, text messages, all this stuff, proving everything that any allegation that I made against him, it was backed up. I mean, it was, and not just a little bit. I mean, it was backed up significantly. And basically his whole thing, which is why we divorced, was that's not true. That's not true. That's not true. We're just friends. That was the whole thing. We're just friends. Well, we're just friends. His we're just friends was sitting there in the courtroom with him, and he was supposed to be marrying her in a month. And we're not even through with our divorce yet. So, so you have to take that into consideration. All right. But it's hard, though. I mean, they go to school a long time to do this, but I love it. So, and another thing, like I said, I am here because, we have rights in this country. And there are people that, this case right here, there's just so much. You have people's rights being trampled on. And then on top of that, the whole reason that they're there is because people who were in positions to protect the vulnerable, in other words, his daughter, didn't do their jobs. And this man should not be facing murder charges for having to defend himself because he had to go rescue his daughter from her attacker because he kidnapped her again because they didn't have him locked up. Because this judge likes to, just give current, former, whatever law enforcement a slap on the wrist. All right, so I gotta quit talking because I'll get to going off about it. It makes me mad. Okay, so let me get right here where I can say this. All right, so here we're going to start. Motion to dismiss felony information on Fifth Amendment grounds. Comes now the defendant, Aaron Spencer, by and through his attorney at Lassiter and Casanelli, and for his motion to dismiss this criminal case under the Fifth Amendment to the United States Constitution states. 1. The introduction. Number 1. The court should dismiss this felony information because it violates the grand jury requirement of the Fifth Amendment of the United States Constitution and stare decisis. I think that's how you say that. Let me make sure. Yes, stare decisis. Okay. Did it right, y'all. All right, stare decisis is not a license. Okay. Is not a license for the state to pursue such an unconstitutional course of conduct. Number 2, following the Supreme Court's incorporation of the Sixth Amendment jury agreement. Now, I know in the paperwork it says, I cannot make my mouth say it. It's UNANIMITY. I understand. I have tried to say it. I cannot. It just will not come out of my mouth. So we're going to say Sixth Amendment jury agreement requirement in Ramos versus Louisiana. Nearly every core criminal procedural protection in the Bill of Rights has been incorporated to the states through the Due Process Clause of the 14th Amendment. The court's incorporation doctrine under the 14th Amendment ensures that the minimum content of due process is not subject to erosion by state legislatures. Number 3, the last unincorporated criminal procedure right is the Fifth Amendment's grand jury clause. Whether to require states to comply strictly with the grand jury clause was last considered in Hurtado versus California. That precedent, if read today in light of recent decisions and historical precedent, cannot justify a process that strips criminal defendants of a foundational procedural protection. Accordingly, Spencer respectfully requests dismissal of the felony information in this case. All right, now we're to the argument. A. Requiring a grand jury for felony charges is deeply rooted in history and tradition because it protects the fundamental principles of liberty and justice. The grand jury clause of the Fifth Amendment to the Constitution provides no person shall be held to answer for a capital or otherwise infamous crime unless on a precedent or indictment of a grand jury. U.S. Constitution Amendment 5. Like the U.S. Constitution, the Arkansas Constitution contains a grand jury requirement, and so did the 1868 version of the same document, Arkansas Constitution of 1874. The purpose of the grand jury requirement is to limit a defendant's jeopardy to offenses charged by a group of his fellow citizens acting independently of either prosecuting attorney or judge. United States v. McCourty. The history of the grand jury dates back more than 1,000 years. From the constitutions of Clarendon and the Aziz, hold on, let me look that one up again. I should have looked at these again before I got on here. Aziz of Clarendon, to the 14th century Edwardian advance in criminal procedural design. In the 17th century, the cases of Stephen College and the Earl of Shaftesbury saw the grand jury emerge as a valued protection of individual liberty against encroachment by the Crown through politically motivated criminal prosecution. The Supreme Court acknowledged the venerable history of the grand jury requirement, including its presence in Clause 39 of the Magna Carta, and the debates on whether it should be interpreted to include not only felonies, but also misdemeanors and petty offenses. However, the court ultimately decided not to incorporate the grand jury clause against the states, holding that state legislatures were free to newly devise any legal proceeding enforced by public authority, so long as they preserve the principles of liberty and justice. And that's a big part of this, preserving the principles of liberty and justice. Although Hurtado established that the grand jury requirement was not incorporated against the states, the decision did not excuse states from ensuring that their criminal procedures offered at least some form of due process, and it did not require Arkansas or other states to strike the grand jury requirement from their constitutions. Therefore, in Arkansas and other similar states, the grand jury requirement remained. However, in 1936, Arkansas amended its constitution to provide that all offenses heretofore required to be prosecuted by indictment may be prosecuted by indictment by a grand jury or information filed by the prosecuting attorney. The following year, based solely on the court's decision in Hurtado, the Arkansas Supreme Court found that Amendment 21 was constitutional within the meaning of the 5th and 14th Amendments of the U.S. Constitution, ushering in an era of felony charges being filed by a lone prosecuting attorney. Penton versus the state of Arkansas. The state's practice of allowing individual prosecuting attorneys to charge individuals with serious criminal offenses directly controverts the Fifth Amendment to the U.S. Constitution. It also creates the risk of executive overreach, which has no roots in the history or tradition of this country or the state of Arkansas. To protect the Fifth Amendment rights of the Arkansans, this court should dismiss the felony information in this case. B. Although Hurtado did not incorporate the grand jury clause, the rationale of Hurtado has been superseded by subsequent incorporation decisions. The right to grand jury indictment is the sole unincorporated outlier among the due process protections contained in the Bill of Rights. Because of the court's decision in Hurtado, Supra, which predated the area of selective incorporation, and then that says see Fairfax Supra, and then up under that, although Hurtado treated incorporation as a matter of procedural due process, the court now applies a substantive due process analysis for incorporating the Bill of Rights. Now, although Hurtado is critically important to the 28 states, including Arkansas, that allow a defendant to be prosecuted for a felony without a grand jury indictment, Hurtado could be called into question in light of the court's decision in Ramos. The court's rationale in Ramos reflected the court's rationale in Timms versus Indiana, in which the court explained that a protection enumerated in the Bill of Rights is incorporated against the states if it is fundamental to our scheme of ordered liberty or deeply rooted in this nation's history and tradition. A close reading of Hurtado shows that the court did not deny the fundamental character of the grand jury right. Instead, the court acknowledged the grand jury's deep roots in both United States history and tradition and the English history and tradition that preceded the foundation of this country. The court recognized that the grand jury requirement was a safeguard to the fundamental principles of liberty and justice. What it rejected was not the idea that individuals had a fundamental right to be free from deprivations of liberty exceeding limitations established by the Bill of Rights, but the idea the Due Process Clause of the 14th Amendment requires identical procedural mechanisms in state and federal prosecutions to preserve the fundamental principles of liberty and justice. In doing so, the court avoided conflict with its previous decision in Murray's Lessee versus Hoboken Land and Improvement. In Murray's Lessee, the court had held that due process requires adherence to traditional common law procedures, demonstrating consistency with fundamental principles rooted in history and tradition. Had the Hurtado court followed this analysis, it would likely have concluded that replacing a grand jury indictment with a unilateral prosecutorial information was incompatible with due process. However, the 14th Amendment had only recently been ratified, and California, like other Western states, was struggling with the practical requirements of convening grand juries in sparsely populated areas. Robert W. Fry incorporated fundamental rights and the grand jury Hurtado versus California reconsidered. That's case law for that. In that context, prior to the court's incorporation decisions of the 20th and 21st centuries, the court concluded that California's practice of proceeding on an information filed by an individual prosecutor was not sufficiently unfair or oppressive to violate the 14th Amendment. This differential procedural due process standard sets Hurtado apart not only from Murray's Lessee, but also from the court's more recent incorporated decisions, in which it has reviewed states' criminal procedures as a matter of substantive due process. Spencer's motion does not require this court to overrule Hurtado, only to read it narrowly in the context of Murray's Lessee. A narrow reading of Hurtado establishes that although a felony information may satisfy the minimal requirements of procedural due process, a substantive due process analysis requires dismissal of the felony information in this case. And under that, recent incorporation decisions establish the Fifth and Sixth Amendment criminal procedural rights apply identically to the states as to federal prosecutions. So in other words, the states, how the criminal procedural rights, are identical to the federal prosecutions. As previously established, the Hurtado court did not find a state's process for filing felony charges to be outside the scope of the 14th Amendment's Due Process Clause. Instead, the Hurtado court decided that due process meant any process that was legislatively intended to safeguard the fundamental principles of liberty and justice. In the many years since Hurtado, the court has overruled most of its precedents from the 19th century, expressly holding that the 14th Amendment's Due Process Clause does in fact require that courts apply an identical definition of due process to state prosecutions as to federal prosecutions. This trend reflects what Justice Black considered to be the original purpose of the 14th Amendment, to extend all the people of the nation the complete protection of the Bill of Rights, to hold that this court can determine what, if any, provisions of the Bill of Rights will be enforced, and if so, to what degree, is to frustrate the great design of a written Constitution. In 2010, the Supreme Court of the United States, publishing the following list of its decisions fully incorporating provisions of the Bill of Rights against the states. And literally we have, it's all case law that's stated. So I'm going to skip over all that case law because there's not really information. It literally just lists all the case law that they considered. Okay. All right. In 2020, the court added the Sixth Amendment's implied requirement of jury agreement to its list of provisions from the Bill of Rights that apply identically to the states. In Ramos, the court acknowledged that the unenumerated jury agreement requirement had never previously been applied to the states. Even in Apodaca versus Oregon, a 1972 case directly on point, nevertheless, the Ramos court expressively overruled Apodaca and found that the Sixth Amendment required jury agreement both in federal prosecution and in state prosecutions. It did so despite the thousands of cases in which state courts had relied on Apodaca, and despite the potentially crushing burden on the courts and criminal justice systems that fully incorporating the jury agreement requirement might impose on states. The Ramos court explained that once a right has been incorporated against the states by the 14th Amendment, that right cannot be interpreted to mean two different things depending on whether it's being invoked against the federal or a state government. Thus, Ramos should be read as implicitly superseding Hurtado by prohibiting states from obtaining felony criminal convictions by procedures that, although they may be arguably consistent with the principles of liberty and justice, are not identical to the federal government's criminal procedures. 4 years after Ramos, the court explained the crucial importance of the jury trial rights, both enumerated and unenumerated, of the Fifth and Sixth Amendments. Thus, the Sixth Amendment promises that in all criminal prosecutions, the accused has the right to a speedy and public trial by an impartial jury. Inherent to that guarantee is the assurance that any guilty verdict will issue only from a unanimous jury, Ramos versus Louisiana. The Fifth Amendment further promises that the government may not deprive individuals of their liberty without due process of law. It safeguards the criminal defendant's well-established common law protections, including the ancient rule and that the government must prove to a jury every one of its charges beyond a reasonable doubt. Together, these amendments place the jury at the heart of our criminal justice system and ensure a judge's power to punish is derived wholly from and remains always controlled by the jury and its verdict. Although the court's justices have offered somewhat different explanations for the court's recent incorporation decisions, their message is clear. States must comply with the jury requirements contemplated by the framers of their actions will be found unconstitutional upon review by the Supreme Court of the United States. This court has abandoned the notion that the guarantees in the Bill of Rights apply differently when incorporated against the states than they do when applied to the federal government. Justice Alito, writing for the plurality in McDonald, argued the well-settled principle that fundamental rights guaranteed in the Bill of Rights are incorporated against the states by the 14th Amendment's Due Process Clause. Justice Thomas concurred with Alito's plurality, but he opined that complete incorporation was necessitated by the plain language of the 14th Amendment's Privileges or Immunities Clause, rather than the Due Process Clause. Let's see. Thomas concurred in part and concurring in judgment. Thomas repeated this argument in his Ramos concurrence 10 years later. regardless of which clause the court prefers. Both analyses point towards finding the 14th Amendment requires Arkansas to strictly comply with the Fifth Amendment's grand jury clause. Since the Hurtado Court determined that the 14th Amendment's due process clause governs the review of how a state files serious criminal charges against individuals like the defendant in this case, and the Ramos Court determined that the due process clause requires uniformity in the protection of constitutional rights between the state and federal criminal justice systems, these two cases, taken together, suggest that the state's failure to comply with the Fifth Amendment's grand jury clause incorporated under the due process. Hold on, I've got to see. I had to write this down because some of my stuff got. All right, there we go. Amendment grand jury clause incorporated under the due process clause requires the dismissal of the felony information in this case. Likewise, since the plain language of the 14th Amendment's privileges or immunities clause provides that no state shall take or enforce any law which shall abridge the privileges or immunities of citizens of the United States, and the jury requirements of the Fifth and Sixth Amendments, both enumerated and unenumerated, protect individuals from deprivations of liberty imposed by an individual representative of the executive branch rather than a jury. The language of U.S. Constitution suggests that a state may not, as here, file felony charges leading to the arrest of an individual like this defendant with any process involving a greater risk of arbitrariness than putting the question to the grand jury. U.S. Constitution amendments. Let's see, 14, 5, 6, according. Ramos, basically you look at the 14th Amendment, the 5th Amendment, 6th Amendment. Ramos and the other recent incorporation decisions demonstrate that it is just a matter of time before the Supreme Court of the United States incorporates the grand jury requirement and invalidates virtually every felony prosecution pursued in the state of Arkansas. Accordingly, the defendant respectfully requests that the felony information in this case be dismissed. Okay, hold on just a second, guys. I got to get a sip of tea. My mouth's dry now. All right, now we're down to the argument. We had A, B, and now we're at C. Amendment 21 to the Arkansas Constitution violates the Fifth Amendment of the United States Constitution. Jury trial rights exist to prevent oppression by the government and to provide a defense against arbitrary law enforcement. Duncan v. Louisiana. Those who wrote our constitutions knew from history and experience that it was necessary to protect against unfounded criminal charges brought to eliminate enemies and against judges too responsive to the voice of higher authority. Providing an accused with the right to be tried by a jury of his peers gave him an inestimable safeguard against the corrupt or overzealous prosecutor and against the compliant, biased, or eccentric judge. Both under English common law and the United States Constitution, the jury exists at the heart of our criminal justice system. To ensure a judge's power to punish is derived wholly from and remains always controlled by the jury and its verdict. Courts should act affirmatively to protect jury rights from encroachment because, as constitutional scholar Sue A. Thomas observed when she argued in favor of incorporating the remaining jury-related rights in 2012 prior to the express incorporation of the jury agreement right by the court in Ramos, Supra, the jury shares with and competes with the judiciary for power. But the jury cannot do anything to regain power when power is taken away from it. As previously established, The framers of the existing Arkansas Constitution acted affirmatively to protect the grand jury enshrined in the Fifth Amendment to the United States Constitution when they drafted Article 2, Section 8 of the Arkansas Constitution. However, Amendment 21 purports to take that right away. When Amendment 21 has been challenged under the Fifth Amendment, the Arkansas Supreme Court has relied on Hurtado to affirm its constitutionality. The Arkansas Supreme Court will strike an amendment to the Arkansas Constitution when the amendment directly conflicts with the United States Constitution. Let's see. And then I've got case striking Constitution being imposed. All right. Nevertheless, in 1937, the Arkansas Supreme Court affirmed the constitutionality of Amendment 21 because of Hurtado and subsequent decisions relying on the same case. Hurtado for the proposition that prosecution by information instead of by indictment is not a violation of the federal Constitution. Okay, that's Spies versus Illinois, so Hurtado. For the proposition of the Due Process Clause did not necessarily require an indictment because an accusation by a preliminary examination was equivalent to an indictment. All right. The Arkansas Supreme Court's subsequent decisions reaffirming Amendment 21 are based solely on the principle of sate decisis. Let's see, and then we got case law. Let's see. Hold on. I'm trying to weed through if it's just quotes from case law, which most of that is. Okay. Existing precedents of the Arkansas Supreme Court are demonstrably erroneous when they conflict with the United States Constitution as interpreted by the Supreme Court of the United States. Although the Supreme Court of the United States has found all but one criminal due process right enumerated in the Bill of Rights to be fully incorporated against the states under the Due Process Clause, the court has, in its own words, shed any reluctance to hold that rights guaranteed by the Bill of Rights meet the requirements for protection under the Due Process Clause. In 2010, the court added to this list of enumerated rights that have been incorporated against the states by holding that the Second Amendment, this is a big part of this, by holding that the Second Amendment is fully incorporated against the states because the right to bear arms is deeply rooted in this nation's history and tradition. Likewise, in 2020, the court held that the Sixth Amendment jury agreement requirement is incorporated against the states under the Due Process Clause. Even a right that is not enumerated in the Bill of Rights may be incorporated against the states under the Due Process Clause. In 2024, the Supreme Court of the United States held that the common law right to be sentenced based only on a jury's findings of facts beyond a reasonable doubt, rather than based on a judge's findings of an additional fact based on the preponderance of the evidence, is incorporated against the states because it is a fundamental right. Because the Supreme Court of the United States has abandoned its precedents related to the non-incorporation of certain rights, neither Amendment 21 nor the principle of stare decisis prevents this court from dismissing the felony information as a violation of the Fifth Amendment's grand jury clause. Existing Arkansas precedent is demonstrably erroneous because it leads to a result that is manifestly unjust. In Arkansas, precedent governs until it gives a result that is so patently wrong or manifestly unjust that a break becomes unavoidable. Although Arkansas precedent is to uphold the constitutionality of Amendment 21 based on the 1884 Hurtado case, as applied by the Arkansas Supreme Court in the 1937 Penton case, this precedent has led to an absurd result. In Arkansas, a prosecutor, disappointed by a grand jury's refusal to indict an individual with a capital or infamous crime, may turn around and file this serious charge unilaterally, directly controverting the demonstrated will of the people. The executive branch of government is the closest thing to the crown that exists in the modern United States, and the prosecutor is a representative of this crown. It was against crown overreach that early Americans sought to protect themselves when they revolted and established the United States Constitution and when they ratified the Fifth Amendment. Nevertheless, in Orsini, the Arkansas Supreme Court upheld the constitutionality of allowing a lone prosecutor take a second bite at the charging apple by filing an information violating not only the grand jury clause, but also the Arkansas General Assembly's statute requiring good cause and the court's permission to go forward with felony charge after a sitting grand jury has determined no charges should be filed. Section D of this statute expressly requires, unless an indictment is found at the term of the court next after the first submission of the charge to the grand jury, the defendant shall be discharged from custody or exonerated from bail, unless, for cause shown, the court shall otherwise direct. Thus, according to the legislature, the only two permissible exceptions to this statutory requirement of discharge exoneration are: 1, if a grand jury returns an indictment, or 2, if a court finds good cause not to discharge or exonerate the accused. In this context, Arkansas precedent regarding Amendment 21 and the Fifth Amendment creates a loophole that was not intended by the legislature. This unintended loophole creates a manifestly unjust legal landscape wherein a person may be charged with a capital crime or other serious felony by an individual member of the executive branch who has already been told by multiple authorities, including 2 constitutions, the Arkansas General Assembly, and a jury without knowledge of the facts of the specific case, that the person should be allowed to go free. Both the manifest justice of this result and the demonstrably erroneous nature of existing Arkansas Supreme Court decisions, given the trend toward total incorporation of all due process rights by the Supreme Court of the United States, require a break with existing precedent, and the court should dismiss this felony information accordingly. An individual's Fifth Amendment right to be free from serious criminal charges except those charged by the indictment of a grand jury shields not only this defendant, but all of us from exactly the sort of deprivations of liberty without due process that the framers sought to prevent. Rather than continuing down the path of affirming a prosecutor's purported power, even when it contravenes the express will of a grand jury, to unilaterally charge people with capital crimes and other serious felonies, this court should look to the language and intent of both relevant constitutions with due consideration to the development of constitutional law in this area since 1884, and it should find that the felony information in this case violates the Fifth Amendment's grand jury clause as incorporated by the 14th Amendment. Wherefore, the defendant, Aaron Spencer, respectfully requests that this court dismiss the felony information in this case for violating the Fifth Amendment's grand jury clause. Respectfully submitted, Lassiter and Castanelli, attorneys for defendant, Michael Kaiser, and then we got the certificate of service. It was filed on June 20th, 2025. Okay, there it is, people. It's just the problem is that right now, if I'm reading this correctly and if I'm understanding it correctly, and I may be wrong, okay? Like I said, I'm not an attorney. But the way that this sounds to me is that the state of Arkansas technically can, if they choose to do so, file these charges against Aaron Spencer without him being indicted by a grand jury. Just because of that loophole that's been created. Even though through years and years and years, they have been indicting on grand jury indictments. All of a sudden now, we want to basically this man's future rely on an overzealous prosecutor and a biased judge. And I know how we all feel about that. We got to get behind this. I mean, we've got to get behind this. This needs to go. We need to get this to go viral, please. Please. If you are not a member of the channel, please subscribe. It's free. And it's the quickest way, the easiest way to support the channel. The more people that subscribe, the better chances we have of getting into the algorithm. Please like this post. That also will help to get this into the algorithm. Hit your notification bell. I do a lot of, this is not the only, case that I report on. I try to report on things where, people are being, either not being taken care of the right way by the United States and its laws, or people that are abusing the laws of the United States for their own personal gain. That's basically what it comes down to. That's what I find it a lot of, either somebody's rights are being trampled on, or somebody's not being protected by the rights that they have. And it just really, in this day and age, we should be better than this as a country. Okay. The state of Arkansas needs to wake up. Sarah Huckabee Sanders, I think her name's Sanders now. She needs to wake up and see what's going on in her state, because literally this case right here sets her state back from a legal standpoint hundreds of years, literally. I mean, it is so blatantly clear that this is purposely being done because they let a predator back out into the community when they arrested him for assaulting a 13-year-old little girl. Not only did he have that charge, during that investigation, what was it, like 43 additional charges of CSAM? And they let him walk out on a $50,000 cash bond. So he gave them $5,000. They handed him a piece of paper that said, oh, an order of protection. You can't go around this person. Do you think that man really cares? He's a former police chief. He's been a police officer his entire life. He knows what an order of protection is. Do you think that he cares? He just assaulted a 13-year-old little girl. He does not care. He did not care what that order of protection said. What he did care about, though, was keeping his secret, which we have now come to find out. His secret goes back a long way. He's been doing bad things to vulnerable, innocent children and young girls pretty much since he was about 20 years old. His entire life. Okay? So, absolutely. Now he had, and the reason it being, children a lot of the times do not tell about abuse. They don't. I can tell you that with 100% certainty because I am a survivor of childhood sexual abuse. To this day, no one in my family knows about the abuse that I suffered at the hands of a family member and also at the hands of a neighbor. Now, all of my family is deceased. Like, my parents are gone, my grandparents are gone. Both of my parents were only children, so there was not a huge, I didn't have a big family to begin with. There was not a lot of people on either side of my mom's side or my dad's side of the family. My parents are gone, my grandparents are gone. I have two brothers, but I have I have no contact with them. They don't know. None of my family knows that as a child I was abused. Not by any of them. It was a neighbor and it was a relative on my mother's side of the family, and it was somebody that I trusted, that I loved, and I never ever thought in a million years that he would ever do that to me at the age of 8 years old. But he did. But I know, as a child, children don't tell. They just don't. So for this little girl to be courageous enough to tell, that was just absolutely astounding. I mean, the courage that she had to do that. And so this man has had this secret since about the age of 20, and he was going to protect that secret. They let him out of jail on here's $5,000, gave him a piece of paper that told him to stay away from her. But what he knew was that, oh man, we're going to court. And evidently at this point, I chose the wrong little girl to abuse. And she's going to testify against me. And my family, my wife, my daughters, my grandchildren, my friends, my former colleagues in law enforcement are going to find out that I'm a predator. So, yeah, he made that decision to kidnap her from her home. So now he's got her a second home. And thank God her father, Aaron Spencer, woke up when her dog started barking, and he went in there and he saw that his little girl was gone, and he knew that that was not right, and he knew the dog was not just barking for no reason. And so thankfully, he did what he was supposed to do. He followed the law. He called 911. He told them that his daughter had been abducted and that he knew who probably had her. And so he called 911, and then he got into his vehicle to desperately try to go find his daughter. And by the grace of God, he rolled up on them, found them, and he chased that man down, ran him off the road. He got out of his vehicle. He went over to that man's vehicle. He got his daughter out. He was taking her back to his vehicle, and then her attacker attacked him. And to defend himself and his daughter, Aaron shot that man. Aaron shot him. He just shot him. He did not go check to see if he was okay. Nothing like that. He shot the man, and he grabbed up his little girl, and he put her back in the car, and they left, and he picked up his phone, and he called 911 again, and he told them, I have found her. And yes, she was with him, and I had to, I had to rescue her from him, but you need to send 911 to check on him because I shot him because he attacked us. Yes, he attacked him because here's the deal. Who out there thinks that man just abducted her to assault her again, and then he was going to take her back home? No, man, that's not the case. What was going to happen was, if her father had not found her like he did, it is so very likely that she would have never been heard from again. Why? Because she was going to testify against him, and he was in the process of getting rid of that problem. So when Aaron interfered with that, Aaron said, no, you're not taking my daughter. And he did what any dad would do if they ever have the chance. They're going to rescue your kid, any parent. If something happens and you have to do a rescue, whether it's rescuing them out of the pool because they fell in and can't swim, or whatever the case, as a parent, you protect your child, and that's what he did. But hey, that dude saw Aaron as a threat too, because the way he's looking at it, well, I have to take her out because she's going to testify against me. He's done run me off the road. He's got her now. Guess I'm going to have to take him out too. And so, yeah, he attacked Aaron. He attacked Aaron with the intent of probably killing Aaron, so that he could, again, get control over the daughter. And like I said, we probably would have never heard from her again. And nobody would have ever testified against him in court. And all of those charges would have been dropped. Or, hey, because of the fact that he assaulted a 13-year-old little girl, and in addition to that, you had over 40 CSAM charges to go along with it. You could have posted him on a higher bond, try to keep him, or you could have you just said, you know what, no bond. I mean, you assaulted a 13-year-old little girl, and then you have all this. There's no doubt in our minds that you've done this to somebody else. We're going to keep you in jail to make sure that you don't do it to anybody else before we, until your trial is set. But no, they didn't. Why? Because apparently, and this comes from people who live there in Lonoke County, Judge Barbara Elmore, she likes to protect anyone who's in law enforcement. If you're present, past, yeah, she protects those people. She keeps their dirty little deeds from being seen. But here, the unfortunate truth, people, is that just as in any other profession in the world, all cops are not good people. Yes, we have officers that are absolutely wonderful and great and do wonderful things and work so hard to protect the community that they vowed to protect. However, we also have, unfortunately, those who take that oath but abuse the power that comes with that badge, with that gun, with that title. And this man was I believe the chief of police in Hamlet, Indiana, or the sheriff, I mean, and then after that, he was a school resource officer. But regardless, we already know that he's been doing this since his early 20s. Why? Because some of his victims have had the courage, now that he's gone, to come out and tell their story. Yep, we actually have people who were, 14 and 15 years old when he was 20, 21, 22. And they were babysitting his children. And he attacked them. Like I said earlier, children don't tell. But thankfully, we do have some that have come forward now. So we know this wasn't just a one-off thing, They'll never be able to blame it on some type of degenerative brain disease because he was 67 years old, or a brain tumor, or anything like that. They'll never be able to say that was what happened. And, they're saying that this was an unjustified action. I beg to differ. His intent that night was to take that young lady's life, because he wasn't going to have her testify against him. He had been keeping this secret a long time and had been successful at it. Yeah, he was not going to, no. His plan was to take her life. And when her father interfered in that, that's what his intention was for Aaron. He was going to take his life as well. And then continue with his plan. Thank goodness Aaron was able to defend both he and his daughter, so that both of them are still alive, because the alternative would have been different. But see, it's like it doesn't matter what the truth is, and it doesn't matter what we have here is a judge who, like I said, from the get-go, dropped the ball. This whole thing, the ball was dropped when they let that man out of jail with a slap on a wrist and a protection order. Now, knowing that there's going to be a trial, knowing that you're going to have a vulnerable young witness testifying against him, knowing all of that, they didn't, well, he's a former cop. Yeah, he's a sick former cop. He should have never been a cop. He should have never been there's no way. But, it happens. But Aaron Spencer and his family, none of that is their fault at all. None of this is any fault of theirs. None of it. The ball was dropped from the beginning, and they're continuing to try to pass the buck. And this was it wasn't justified. The means wasn't justified. No, it was. Because if he had not taken the life, I'm sorry. Hold on just a second. I'm so sorry. Okay, guys, I'm so sorry about that. But anyway, as I was saying, yeah, we need to get behind this, y'all. Let's get this out there. We've got to, get the power behind this, because this should not be happening in our court systems this day and age. Okay, and like I said before, none of this is the fault of Aaron Spencer or any of his family. They should not be paying for the ball that was dropped. The ball was dropped a long time ago. But that ball could have been stopped, but it wasn't. And then they're continuing to play cover up. So let's get behind this, y'all. So please, like I said, please like like this post, subscribe. It's free. It's the quickest and best way to support the channel. Please hit that bell so that you'll get a notification when we drop new content, and share, comment. I love talking to you in the comments. And let's get this going. Let's get this. Let's help this family. All right, guys. I hope y'all have a good day. Y'all have fun. Be safe. And always know that you're loved. I love you guys. Bye.